Hi everyone, this is Attorney Poonam Minhas back with another immigration update. I wanted to thank everyone that has been coming back to check for these updates. And if you're new, make sure to hit subscribe and make sure to like and share with your friends and family. This might be helpful to them. So today's topic is about removal proceedings and winning your adjustment of status case before the immigration court or the immigration judge. A lot of times people have said, okay, I won my case. Is my green card just going to be mailed to me? The answer is no. So today's video is going to be about tips and tricks on what to expect and what to do, what steps you or your attorney may need to take in order for you to actually get the green card. Trust me, it's not just going to be mailed to your home or it's not going to walk over to your house like some people have told me. Okay, so first and foremost, you're in front of the court and it's now time for your merits hearing. It's also known as an individual hearing. And the judge gives you an order. And the order says, respondent has been granted adjustment of status before the court. Yay, great. And the trial attorney, also known as OPLA, decides to not even appeal the decision. Says, okay, I'm going to waive appeal. Means that they're not going to fight the decision from the court. And you now have this order from the court. Yay, everybody's happy. You're throwing a party. But now what happens next, right? You're like, okay, where's my green card? This is what you need to do. Number one, you want to make sure, or your attorney needs to make sure that they contact the trial attorney so that your file makes its way to USCIS. So USCIS is aware that you won your case before the court and you're eligible for adjustment of status to get a green card, right? So you already got granted before the court. The court already determined that you are eligible and you have been granted for adjustment of status. So you want to make sure that that file makes its way to USCIS. How do you do that? You or your attorney may follow up with the trial attorney to make sure that's happened. Then you may want to contact USCIS to set up an info pass. And you want to appear for the info pass appointment and show them the order from the court showing that you have won your adjustment of status. You confirm all your information, and within maybe 30 to 60, sometimes even 90 days, they will make sure that you have your green card and you receive it at home. That's the process that's not really spoken about. Some people don't know about it. So I wanted to share this video today to help you out, just in case if you're stuck there. But that's not all. I also wanted to make sure that this also covers individuals who may not have such an easy path and may not have been granted adjustment of status before the court. So what happens? So let me give you a hypothetical. You go in front of the judge and you have your hearing, your individual hearing, and the judge says, okay, you're not being granted adjustment of status. You get an order saying you're denied adjustment of status. What happens next? Well, you have within 30 days, if you and your attorney or your attorney decides to reserve appeal, to appeal the judge's decision before the Board of Immigration Appeals within 30 days. You don't want to file late. You don't want to wait until, the last minute to file this thing, because you want to make sure that you are appealing on a timely basis. And if you have more questions about what the process is with the Board of Immigration Appeals, you may want to pick up the phone and schedule a consultation to discuss further, because it can't be just covered in this video. Okay, let me give you another example. Now, you won your adjustment of status before the court. Great, everything is wonderful. But the trial attorney says, Judge, I want to reserve appeal. Meaning the trial attorney does not think that you should have gotten that adjustment of status grant before the court. So what happens next? Now the trial attorney has an opportunity to file an appeal based on the judge's decision. And they have within another 30 days to file that appeal. That's fine. What do? You now have to wait, and you or your attorney may need to sit down and discuss a game plan, because if there is something that's filed by the trial attorney before the board, you want to have an argument ready to counter that argument that is filed by the trial attorney. So these are things that might be adverse factors or different scenarios that you might run into if you don't have a straightforward adjustment of status grant, and then the trial attorney decides, oh, you know what, I don't want to appeal it, I'm happy, I'm okay with this decision, and then you file the process, then you go with the process which focuses on how you can get your green card. But there might be other issues that may come up during the time that you get a decision, whether it's positive or whether it's negative, with other issues that might come up. So I hope today's video was helpful. Remember, it's an informational video. Anything that's specific to your case, you want to discuss these details with an experienced immigration attorney. So again, if you want to get more updates, make sure to hit subscribe and join us back for more immigration updates. Thanks for joining us today.